Hi, I'm Ross Simpson and I'm a solicitor in the Dispute Resolution and Litigation team at Shepherd and Wedderburn. Say your litigation has reached the stage where the matter has been determined and an award of expenses has been made. If you're the unsuccessful party, then you may look to appeal. As mentioned in our video on the Scottish court system, there are a number of forms for litigation in Scotland, many of which have their own rules of procedure. In this video, we will focus on the appeal procedure in the Sheriff Court and in the Court of Session. Since the 1st of January 2016, appeals from the Sheriff Court must be brought to the Sheriff Appeal Court. Some decisions of the Sheriff may only be appealed with permission of that Sheriff. For example, the decision on whether to allow a party to amend their pleadings or whether to recall assist. Where the decision of the Sheriff is a final disposal of the case, whether that is after a proof where evidence has been heard or otherwise, it is not necessary to obtain the permission of that Sheriff in order to appeal. An appeal must be made within 28 days of the date on which the decision was given, although that deadline is subject to specific statutory requirements that exist for certain types of cases. The applicant must lodge an appeal form with the court specifying the grounds for the appeal. The appellant can also request that the Sheriff who made the decision provide a Sheriff's note, setting out the reasons for the decision, insofar as these are not already set out in the judgment. The appeal form is then intimated to the other parties, and the Clerk of the Court will issue a timetable setting out the procedure to be followed. The other parties to the action are entitled to make submissions of their own on the appeal, and indeed may themselves make cross-appeals, challenging the original decision. Appeals beyond the Sheriff Appeal Court are made to the inner house of the Court of Session and will require the leave of either of those courts. As we mentioned in our video on the Scottish court system, the Court of Session is both a court of first instance and a court of appeal. Where the court of first instance is the Court of Session, the appeal is made from the outer house to the inner house. This process is known as reclaiming and is made by way of a reclaiming motion. There are 3 general time limits depending on the type of interlocutor being reclaimed. An interlocutor can broadly be understood as an order of the court. Interlocutors dispensing of the whole case or the whole merits do not require the leave of the court, and they may be reclaimed as of right within 21 days of the date on which the interlocutor was pronounced. Certain other interlocutors that do not dispose of the whole case may be reclaimed without leave, but within a shorter time limit of 14 days. This includes interlocutors granting or refusing interim interdict and interlocutors disposing of part of the merits of the case. With regard to all other interlocutors, leave is required, and the reclaiming motion must be made within 14 days. The appellant must therefore ensure that they obtain leave within 14 days of the date on which the interlocutor is pronounced. Once the reclaiming motion is underway, the court will issue a timetable setting out the various procedural steps, such as the lodging of the grounds of appeal, notes of argument, and any appendices containing the material that is to be relied upon. New evidence can only be submitted if it could not, with reasonable diligence, have been available during the original hearing, and it must of course be relevant to the matters at hand. For further information on appeals, visit our website or get in touch with your usual Shepherd and Wedderburn contact.